All right, hello and welcome. This is Win Without Law School. I am Arizona lawyer Julie LeBenz, and today we are going to talk about how to create a case strategy if you are looking to modify or enforce your underlying court order. So you've already gotten divorced and you have a divorce decree, or you've already established custody and you have a custody establishment order that lays out legal decision-making, parenting time, and child support. So either you have an underlying decree or an underlying establishment order, and you're wanting to make changes to it, or you're wanting to enforce the terms. That's what we're going to talk about today. All right, we're going to go through 5 different parts of today's lecture. First, we're going to talk about how and why to create a case strategy. Number 2, we're going to go through the modification laws in Arizona. Part 3, we're going to talk about how to create a modification case strategy. Part 4, we're going to go through some enforcement laws. And part 5, we're going to talk about how to create an enforcement case strategy. All right, why and how to create a case strategy? Well, it helps you get clear about your desired outcome. You put yourself in a position to tell the judge and the opposing party what your desired outcome is. It helps you to determine whether you're being reasonable or not. Now, for modification, what are you wanting to modify? Your options are spousal maintenance, if that was ordered in your decree, legal decision-making, parenting time, and or child support. And then if you're seeking to enforce, what part of your decree or order, or what parts, if there's more than one, do you believe have been violated? So look back at that actual language. And then what facts do you have to prove the violation? Keep in mind that if you're going to file a modification or enforcement or both with the court, you likely are going to want to have more than one claim. You know, if you want to modify child support, but there's also some things in your parenting plan you want to change, it makes sense to do that all at once instead of, 2 separate actions at different times. And with enforcement, if you've got just one violation and it isn't something that is hugely serious and endangering to the child or something like that, then to make your case stronger, it can be a good idea to have 2, 3, 4, 5 or more claims of violations of the document, in case the one you're looking to make, the other side has some wiggle room to get out of it. And also so that the judge isn't kind of like, oh, you brought this whole case just based on this one violation. So I would encourage you to either wait a little bit to get some more potential violations on the table to throw into one case, or to maybe try to resolve it directly with the other side. But really evaluate your case. If you have just one violation of the order that maybe isn't that serious, it might not be worth taking it to court. All right, let's talk about the laws. Are you looking to modify spousal maintenance? If so, we're going to look at the laws for that. Legal decision-making and or parenting time or child support, we're going to look at different laws for each of those categories. One of the main things to keep in mind is that there is a standard of proof that you will need to meet if you're seeking to modify. And that standard of proof is that there's a substantial and continuing change in circumstances that merits modifying the decree or underlying order. So what we're looking at here is that the person seeking to modify, they're going to need to tell the court how there's been a substantial and continuing change in circumstances that merits modifying the underlying decree or order. If you're not able to show that, you don't qualify for a modification. All right, we've got a question. What if you need more information from an expert before changing something? Well, you'll want to gather that prior to filing for the modification. So working with the expert, have them write a report, have them do an evaluation. You can potentially do that before you initiate your case to have that evidence ready to go. All right, so back to the standard of proof. This is going to be for any type of modification, spousal maintenance, legal decision-making, parenting time, child support. You need to show a substantial and continuing change in circumstances that merits modifying the decree. So there could be a substantial and continuing change, but it doesn't merit modifying the decree. So you need to connect the two and show, For example, we can't keep this week on, week off parenting plan because mom is moving to another state and there's no way we can do week on, week off. That's a substantial and continuing change. Spousal maintenance. Let's say you're the one paying and you've lost your job, you became disabled, like all these things happen that have impacted your income and financial resources in a negative way. That could be facts to show a substantial and continuing change in circumstances. For child support, the court is looking at what is the end result. So if you want to modify child support, the court's going to be looking at, do you have a 15% change in the current amount versus what you want to change it to? So the court is going to be looking at not just, oh, you got a new job and that's substantial and continuing because your pay increased and that's going to be your new pay rate going forward, but you throw that into the calculator and let's say it only changes child support by $100 a month, and that doesn't amount to a 15% change, then the court may say, oh, well, you don't qualify to modify. So in creating your strategy, you want to make sure that the things you're requesting to modify, you're going to be able to prove this substantial and continuing change in circumstances merits the modification you're requesting. What can you request to modify? Spousal maintenance, legal decision-making, parenting time, and/or child support. You'll notice missing from this list is property. So if you had an underlying divorce and you're unhappy with the property division provisions of your decree, those in general cannot be modified. All right, let's talk a little bit more about modifying spousal maintenance. The statute here is 25-327, and here's that standard. The provisions of a decree respecting maintenance or support. So they're talking about spousal maintenance or support, child support, may be modified or terminated on a showing of changed circumstances that are substantial and continuing, except as to any amount that may have accrued as an arrearage. So the court is looking, like if you're going to modify, the question is, well, when does that become effective? If I'm paying $500 a month in spousal maintenance and it's going to get reduced to $250 a month, when does that $250 start? Well, according to the law, that starts when the order is entered or the petition is filed. So you'll see here at the end, it says effective on the first day of the month following notice of the petition for modification or termination, unless the court, for good cause shown, orders the change to become effective at a different date, but not earlier than the date of filing the petition for modification. So the filing is important because that is the soonest that the modification can be retroactive to. So if you're paying $500 and you win on this argument to get it reduced to $250, that $250 obligation is going to start from the month that you filed your petition, or if you can show good cause, you can potentially go with a different date, but it can't be earlier than the date of filing the petition. So keep that in mind. Also, this middle sentence that I have in bold, this is where that language is about how you can't modify the property disposition parts of your decree. It says the provisions as to property disposition may not be revoked or modified unless the court finds the existence of conditions that justify the reopening of a judgment under the laws of the state. So getting your whole divorce decree reopened, there's a very high standard for that. Definitely consult with a lawyer if you have something going on in that regard. But overall, you're going to run into a lot of hurdles if you're looking to modify the property division provisions, because that's not allowed. But spousal maintenance, you can upon a showing of changed circumstances that are substantial and continuing. And that change can start as of the month you filed the papers if you're victorious at getting your change granted. Okay, we've got a question. So I believe the question is about terminating an obligation. And often with a termination, it doesn't just happen automatically in the system because, for example, with spousal maintenance and child support payments, they go through the clearinghouse. And so often there needs to be a notice to the clearinghouse saying, oh, this support obligation is now terminated. It's done, and that's through filing papers with the court to get an official termination order that can then be sent to the clearinghouse. So although there may be an end date in the papers, sometimes you'll still need to go back, in particular with child support, and actually terminate it to get it to end. Okay. Some section B of 25-327 says, unless otherwise agreed in writing or expressly provided in the decree, the obligation to pay future maintenance is terminated on the death of either party or the remarriage of the party receiving maintenance. So if you are obligated to pay spousal maintenance and your ex dies or remarries, and there's nothing in your decree that says anything about what happens upon death or remarriage in regards to spousal maintenance, then that would be a time to go to the court, petition to terminate, citing the statute and showing the evidence that your ex-spouse passed away or remarried. And then subsection D, the court may suspend the imposition of future interest that accrues on a judgment for support if the petitioner is incarcerated or has physical or mental disabilities to the extent that the person is unable to maintain employment. So if you fail to pay spousal maintenance, per law, the amount that's unpaid accrues interest at 10%, and it can really add up fast. And so this is saying that the imposition of interest on the judgment will be suspended if you're incarcerated or you're mentally or physically unable to maintain employment. Okay, so modifying spousal maintenance, what can you request if you want to modify? Well, you can request to increase the amount paid. You'll need to name the exact amount you're requesting for the increase, and of course, show the substantial and continuing change in circumstances that justifies your requested increase. You could request to decrease the amount paid per month. You'll need to name the exact amount you were requesting for the decrease, as well as show the substantial and continuing change in circumstances that justifies the decrease. You could request to extend the duration. How long is spousal maintenance paid? Let's say under the decree it was ordered for 3 years, but you want to extend it for 5 years. Well, you're going to need to explain that you want a 2-year extension, and you're going to have to show what substantial and continuing changes in circumstances justify extending it for 2 years. Or you could look to decrease the duration and or terminate it. You'll need to name when you want the spousal maintenance obligation to end or why it should be terminated, and explain the substantial and continuing change in circumstances that justifies decreasing the duration. And then you can request to terminate. All right, let's talk about legal decision-making and parenting time. If you're looking to modify legal decision-making or parenting time, what can you request? Well, for legal decision-making, which I've abbreviated to LDM, you can modify from joint to sole, or you can modify from sole to joint. And of course, this doesn't have to be on every single category of legal decision-making. You know, there's education, healthcare, religious training, and personal care decisions. Those are the four categories of decision-making within legal decision-making. And you could just request to modify education or just decisions related to healthcare. So it doesn't have to be a full request to modify everything under the legal decision-making umbrella, or it could be. And then for parenting time, which I've abbreviated to PT, do you want to change the weekly schedule? Do you want to change the summer schedule? Do you want to change something about vacations? Do you want to change the holiday schedule? Do you want to change the method or methods of communication between the parents or between the parent and the children during the other parent's parenting time? And keep in mind, you can make requests for all of these. You don't have to narrow down to just one. And like we talked about, if you're going to move to modify and you're wanting to make changes in multiple areas, that is the time to do it. Don't piecemeal it into different cases, put it all into one case. How long after you're divorced or your custody order is established, do you have to wait until you can request to modify legal decision-making and or parenting time? And what is the procedure? This takes us to 25-411. And what it says is that 1 year from the date of the entry of your decree or establishment order, that's how long the court wants you to wait. They want you to wait a year. However, there are exceptions. You can seek to modify decision-making or parenting time earlier than 1 year if you can show that you have reason to believe your child's present environment may seriously endanger your child's physical, mental, moral, or emotional health. At any time after a joint legal decision-making order is entered, a parent may petition the court for modification of the order on the basis of evidence that domestic violence, spousal abuse, or child abuse occurred since the entry of the joint legal decision-making order. And then you can seek to modify after 6 months if you are saying that the other parent has failed to comply. So after a joint legal decision-making order is entered, 6 months after, a parent may petition the court for modification of the joint legal decision-making order based on the failure of the other parent to comply with the provisions of the order. So there are exceptions to this for a co-parent that's part of the military. So if you're dealing with a co-parent who's in the military or you're in the military, there's more to this statute on that point. So dig into 25-411 or seek legal advice, because there's much more here. And I'm not going to go into that today because I'm guessing we aren't going to have a lot of people with that military issue. However, I want to bring that to everybody's attention. Okay, continuing on with this statute, we've got section J, and this talks about what is the court supposed to do when the one side or the other is requesting to modify parenting time rights. And the court can modify the rights if it would serve the best interest of the child, and that's the 25-403 standards. But the court cannot restrict a parent's parenting time rights unless it finds the parenting time would endanger seriously the child's physical, mental, moral, or emotional health. Now, when we talk about restricting parenting rights, to me, that focuses on like supervised parenting time, putting some restrictions on or you can't have overnights, things like that. And so the court isn't able to start restricting and limiting a parent's parenting time unless there's good cause, unless there's serious endangerment to the child's physical, mental, moral, or emotional health. After a legal decision-making or parenting time order is in effect, one of the parents is charged with a dangerous crime against children, child molestation, or an act of domestic violence in which the victim is a minor, then the other parent can petition the court for expedited relief. And pending the expedited hearing, but between the time you petition the court and you actually get to see the judge, the court can issue an order suspending parenting time or changing legal decision-making ex parte, which means without hearing from the other parent. In order to modify legal decision-making or parenting time, you'll need to submit an affidavit or verified petition setting forth detailed facts supporting the requested modification. So that's going to be showing the substantial and continuing change in circumstances, exactly what you're looking to modify, what you want to change it to, together with a copy to the other parties. The court will look at this initial filing, and based on your allegations in the initial filing, the court will either say, okay, this is going to continue forward and I'm going to set a hearing, or the court is just going to deny the petition. It says the court shall deny the motion unless it finds that adequate cause for hearing the motion is established by the pleadings, in which case it shall set a date for hearing on why the requested modification should not be granted. So keep that in mind. If you are filing for a modification, you have the burden of proof. And when you file your initial request to modify, you're going to need to include enough detail to show the judge there's been a substantial and continuing change in circumstances, and I'm entitled to a hearing on this as a result. So don't just think you can check some boxes on the pages, file your papers, and it's a done deal. There is this standard that needs to be met in order for a post-decree modification case to move forward. All right, subsection M. Now keep this in mind. The court shall assess attorney's fees and costs against a party seeking modification if the court finds that the modification action is vexatious and constitutes harassment. So if you're dealing with another party that is just coming back to court and seeking to make changes to the court order just to harass you or be a vexatious litigant, you want to start gathering evidence to that effect and then make a request for attorney's fees and costs. Now, of course, proving vexatiousness and harassment can be challenging. Just having differing points of view about what's best for your children does not amount to harassment and vexatious litigation. It's going to need to be more than that. So keep that in mind, that qualifying for a fee award under subsection M isn't necessarily going to be the most important. All right, we've got a question. What is the affidavit? This is back to subsection L. Is it separate from the petition to modify? So you'll see it says an affidavit or verified petition. What the court is getting at is that what you file must be a sworn statement. When you are requesting to modify, it needs to be in the form of an affidavit, which is an under oath statement, or a verified petition, which a verified petition is where you're swearing and affirming that everything in it is true. And so that's really the crux of it. The actual format isn't as important, whether it's in the form of an affidavit or a petition. If you're using the courts fill in the blank forms, they're going to give you a petition to fill in, but at the end of it, it's going to have a verification part where you sign off saying, yes, everything in here is true and accurate to the best of my knowledge and belief. And that's what this is getting at here, is when you file your papers, because the court wants to make sure you're not wasting the court's time or being a vexatious litigant or engaged in harassment, you need to swear and affirm that, yeah, what I put in here is true. So that's really what we're getting at with the affidavit or verified petition. Okay, now we're looking at subsection N, and this is referring back to L, okay? And it says L does not apply if the requested relief is for the modification or clarification of parenting time and not for a change of legal decision-making. So this issue where the court looks at your modification pleading and decides whether or not to grant the relief, they're saying that that procedure does not apply if the requested relief is for parenting time only. In other words, the court will hear the parenting time request. You don't have to go through this initial, will the court hear it or not? But if you're going to try to change legal decision-making, the court is going to need to see that there's adequate cause before they'll grant you a hearing on that. Child support. What if you want to modify child support? What can you request? Well, you can request to increase the amount that either, that you would receive. I don't know if I've ever seen the payer request to increase. So if you are receiving child support, you can request to increase the amount. And you'll want to see if there's around a 15% difference between the current child support obligation and your requested increase, because that's really what the court's going to be looking at. And there's also a separate procedure you can follow called a simplified child support modification, where you just fill out some papers, show the 15% change, and the court can order it if the other side doesn't contest within 20 days. So it's important to look at this from that perspective. Is the change in income for either parent or expenses for the child or something like that, is that going to make a big enough change in the child support calculation to merit seeking a modification? You can also seek to decrease the amount of child support to be paid each month, again, looking at that 15% difference. You can also seek to terminate child support. If the minor child named in the child support order has turned 18 or graduated from high school, whichever happens later, you qualify to terminate your child support order. So that's something to definitely mark in your calendar if you're the payer. Oh, look, my child, right when my child graduates from high school, I'm going to be filing to terminate child support. Or, if they turn 18 after they graduate from high school, then you would look to terminate after they turn 18. Now, 25503 is about child support, and here's that same standard coming up again for a modification or a termination. You have to show a change circumstance that is substantial and continuing. And then again, it goes into this question of, well, if we're going to modify child support, when does the new amount start? And it's going to be effective on the first day of the month following notice of the petition for modification or termination, unless the court for good cause shown orders the change to become effective at a different date, but not earlier than the date of filing the petition. So again, if you want to modify, the date you file is important because that's the soonest the modification could go into place. Now, you may have to go through a contested process, and then when the court issues their order, it'll be retroactive. They'll say, okay, the case was filed in January. We didn't resolve it until June, but it was resolved with child support being modified. So the modification is going to be effective as of January. And so if the payer has paid additional amounts, those would be credited to them in the child support clearinghouse. Okay, we have a question. How about health insurance termination? That's in here. Great question. It's actually the next sentence here. It says the addition of health insurance coverage or a change in the availability of health insurance coverage may constitute a continuing and substantial change in circumstance. And what that's getting at is, what are the numbers? Is it a difference of $5 or is it a difference of 500? Obviously that's going to make a big difference about whether or not modifying is worth it. But yes, a change to health insurance can amount to a substantial and continuing change in circumstances that modifies or that justifies a modification of child support. Okay. The order of modification or termination may include an award of attorney's fees and costs to the prevailing party. So you can seek attorney's fees if the other side is giving you resistance or there's a big financial discrepancy between the two sides. We have a question. How about remarriage? Would that be a substantial and continuing change in circumstances? Possibly. You're going to need to put in more information about how the marriage changes the gross income or the amount being paid for health insurance coverage. You've got to think about that child support calculation. When we go to the child support calculator in Arizona, you're putting in each spouse's gross income. And so if one of I shouldn't say each spouse, each co-parent, and if one co-parent gets remarried, their new spouse's income is not put into the calculation. So that remarriage, at least if you're just looking at gross income, it's not going to impact the child support calculation. Now, as part of the child support calculation, the parents get to put in certain credits for money that they're paying on the children's behalf, such as for health insurance coverage for the children, special needs expenses, gifted expenses. Those are some of the things coming to mind. So if there's changes in what's being paid for health insurance on behalf of the children, yeah, that could change the child support calculation. But again, how much is the difference? And then would need to run the calculator to see what that looks like. All right, now terminating child support. This is under 25.327 subsection C. Unless otherwise agreed in writing or expressly provided in the decree, provisions for the support of a minor child are not terminated by the death of a parent obligated to support the child. So we saw with spousal maintenance, if your ex-spouse dies, then spousal maintenance ends unless you had some different language, some different outcome in your decree. But child support's different. If the parent that's obligated to pay child support dies, then the obligation is not automatically terminated. So if a parent obligated to pay child support dies, the amount of future support may be modified, revoked, or commuted to a lump sum payment to the extent just and appropriate in the circumstances, and has priority equal to the right for family allowance in the probate statutes. Past due support has equal priority for claims under probate laws. So if you are receiving child support and the payer passes away, I would definitely get legal advice about how to make a claim and how to get child support out of your deceased co-parent's estate if there's money to collect from. All right, and then we've got subsection D. The court may suspend the imposition of future interest, on the judgment if the payer is incarcerated or has physical or mental disabilities that make it unable to maintain employment. So if you've got a co-parent that's incarcerated or has serious physical or mental disabilities, and they're not paying child support, you may not get the interest on that amount owed pursuant to subsection D. All right, part 3, how do you create a modification case strategy? You'll want to ask yourself some questions. Number 1, what are the significant and continuing change in circumstances or changes? If you have more than one, list all of them. If there's just one, make sure it's compelling. For spousal maintenance, what is your requested change to the amount and or duration? And what's the significant and continuing changes in circumstances justifying that? For legal decision making, what's your requested change? Why is it in the best interest of your children? For parenting time, what is your requested new parenting plan? Why is it best for your kids? And for child support, what is the new amount of child support you're requesting? Is it 15% different than the current child support obligation? So go through those questions as you're considering a modification and start creating a strategy around it. All right, let's move to enforcement now. There's different elements to enforcement. And so what we're going to look at here is a situation where your ex failed to comply with a court order to pay debts. All right, this could be through your divorce decree. This could be through your establishment order, because there can be an order to pay hospital expenses related to the birth of a child. So this doesn't only come up in the divorce context, but most often that's where it would come up, because debts are divided in a divorce. And so we have this 25-318P, and it explains that if a party fails to comply with an order to pay debts, the court may enter orders transferring property of that spouse to compensate the other. That's pretty powerful. Rather than just getting a paper judgment and then having to try to convert that into money, you can actually ask the court to order certain property in your spouse's possession to be transferred to you, for you to either become the owner and then use that property, or sell it to get your money. So that's interesting. If the court finds that a party is in contempt as to an order to pay community debts, the court may impose appropriate sanctions under the law. A party must bring an action to enforce an order to pay a debt pursuant to this subsection within 2 years after the date in which the debt should have been paid in full. So there is a statute of limitations on seeking to collect on an unpaid debt against an ex-spouse. What about a parenting time violation? Well, we've got 25-408J, and it states that the court shall assess attorney's fees and court costs against either parent if the court finds that the parent has unreasonably denied, restricted, or interfered with court-ordered parenting time. So the parent making that accusation, the parent claiming a denial, restriction, or interference with court-ordered parenting time, will need to show where in the court order it states this parenting time they were entitled to, and then show the facts substantiating that they were denied, restricted, or that their parenting time was interfered with. Here's more on parenting time violations. If a court, based on a verified petition, and after it gives reasonable notice to an alleged violating parent and an opportunity to be heard, finds that a parent has refused without good cause to comply with a visitation or parenting time order, the court shall do at least one of the following: find the violating parent in contempt of court, order visitation or parenting time to make up for the missed sessions, order parent education at the violating parent's expense, order family counseling at the violating parent's expense, order civil penalties not to exceed $100 for each violation, order both parents to participate in mediation or some other appropriate form of alternative dispute resolution at the violating parent's expense, or make any other order that may promote the best interests of the child or children involved. So what you may be gathering here is that if you are requesting to enforce, you're also going to want to tell the court what your requested relief is. So it's not just, look, this was the violation. You want to show the violation, but then you also want to show what you want the court to do about that violation. And here's some guidance. We saw that in the last slide, for a parenting time violation, you can get an award of your court costs, your legal fees and costs. But then we have this statute as well, where the court can put the violating parent in contempt of court, can give you additional parenting time for the time that you missed, can order a parenting class, can order family counseling, can order civil penalties, mediation, or anything else that may promote the best interest of the child. So think about that when you're going through this. What would make you whole? If you can prove your violation and the court is going to give you a remedy, what remedy do you want? It doesn't mean you're going to get it, but you're going to need to tell the court the remedy you want in order to be in a position to get it. Within 25 days of service of the petition, the court shall hold a hearing or conference to review noncompliance with a visitation or parenting time order. So the courts do want to get these types of enforcement actions resolved relatively quickly. Court costs and attorney's fees incurred by the non-violating parent shall be paid by the violating parent. In the event the custodial parent prevails, the court in its discretion may award costs and attorney's fees to the custodial parent. So if you claim the other side violated the parenting time agreement and it goes to trial and you lose and there's no violation proven, then you could potentially be ordered to pay your co-parents legal fees and costs if you were to lose. So keep that in mind. You definitely want to have a strong case going into court. How about support orders? But we have 25-508A, and it says that any judgment, order, or decree, whether arising from a divorce, custody determination, or any other proceeding regarding support that provides for alimony, spousal maintenance, or child support, may be enforced as a matter of right by lien, execution, attachment, garnishment, levy, appointment of a receiver, provisional remedies, or any other form of relief provided by law as an enforcement remedy for civil judgments. An affidavit regarding all payments in default under the support order, along with a copy of the underlying support order, shall be filed with the clerk of the Superior Court along with the appropriate writ, application, petition, or motion. So this is showing you that you have other means to collect. If there is money owed for spousal maintenance or child support, then you can seek to enforce that by a lien. A lien, if somebody owes real estate, you can get a lien against their property. Of course, you want to do the right steps for that. That's very important. So I'd work with an attorney on that. Execution is where you lien the property and then seek to execute on it. Attachment, you can attach to different assets and look to collect that way. Garnishment is where you can garnish the other side's wages or bank accounts. Appointing a receiver, you can appoint somebody to take the property and liquidate it. And then there's some other provisional remedies as well. This does get complicated. I'm more bringing this up just to show you that there's other rights, but I again encourage you to work with an attorney if you're wanting to pursue this type of collection effort. Okay, so then we've got enforcement of failure to pay child support. We're looking at, all right, just one second. I'm recording right now, okay?
Mama, I just had a chocolate.
Okay, that sounds great. Okay, sorry about that. Okay, so we're looking at enforcement failure to pay child support. This is 25-503B on a showing that an income withholding order. So that's where you're looking to garnish the other side's wages to get your child support. So that garnishment, known as an income withholding order, if it's been ineffective to secure the timely payment of support and that an amount equal to 6 months of current support is accrued, the court shall require the payer, the child support payer, to give security, post a bond, or give some other guarantee to secure overdue support. Look at subsection N. If a party entitled to receive child support or spousal maintenance has not received the payments, the party entitled to receive the payments may file with the clerk of the Superior Court a request for a judgment of arrearages and an affidavit indicating the name of the party obligated to pay support and the amount of the arrearages. Arrearages are amounts that were owed in the past that are unpaid. So if you're obligated to pay $500 a month and you didn't pay that for 6 months, that 6 months you didn't pay is an arrearage. Okay, let me just, so then it goes through some of the procedure. Overall, if a hearing is not requested within the time provided, or if the court finds that the objection is unfounded, the court must review the affidavit and grant an appropriate judgment against the party obligated to pay support. So you don't have to have a support if you're asking for the arrears judgment. The court can give that to you, and then you can seek to collect on that arrears judgment. What if the other side is engaged in litigation misconduct? Well, we have 25-415. The court shall sanction a litigant for costs and reasonable attorney's fees incurred by an adverse party if the court finds that the litigant has done any one or more of the following: knowingly presented a false claim with knowledge that the claim was false. Now, those statutes listed there are related to best interests of the child. And then I believe 3 and 4, I think that's child abuse and substance abuse, domestic violence. So presenting a false claim in the child custody context, knowing that it's false. Knowingly accusing an adverse party of making a false claim with knowledge that the claim was actually true. Again, this is in the child custody context. Violated a court order compelling disclosure or discovery, unless the court finds that the failure to obey was substantially justified, or that circumstances make an award of expenses unjust. If the court makes a finding against any litigant under subsection A, it may also impose additional financial sanctions, institute civil contempt proceedings, modify legal decision-making or parenting time. And then just keep in mind that a false claim does not mean a claim that is merely unsubstantiated. A false claim is where you know it's false, and proving that, of course, can be difficult. But if you can, the court has all these remedies that the court can award. And of course, attorney's fees and costs can be awarded as well. All right, we've gotten to our summary. Modification. You got to figure out what are your substantial and continuing changes in circumstances. With parenting time, that's usually relatively easy. Circumstances change as kids get older, but spousal maintenance, that may be a little more challenging. Legal decision-making, that could be a more complex argument. And then, the child support, you're looking at that 15% change. If you've determined that there are substantial and continuing circumstances that merit justifying or merit modifying spousal maintenance, then what are you requesting the amount and duration be modified to? For legal decision-making, what are you requesting legal decision-making be changed to? Same thing for parenting time and same thing for child support. And are you at that 15% difference? Enforcement. What part or parts of your decree or establishment order were violated? Jump into that language, because sometimes you think the papers say a certain thing and then you look at it and the language is actually more specific, or like you just really want to make sure that what you believe is what the document says, is what it actually says, and then that the facts you're going to allege as the violation actually violate that part of the document. So you need to have the part of your decree or order that you believe has been violated, and then you need to present the facts or documents that support or prove your allegation that the opposing party violated the decree or custody order. And then you need to let the court know what you want the court to do about this violation. Do you want an award of attorney's fees and costs? Do you want make-up parenting time? Do you want family counseling ordered? There were all those different remedies that we went through. So what are you wanting to request?